A very good morning and warm wishes to everyone. I, Dr. Disha Vidyarthi, on the behalf of whole fraternity of IIMT College of Science and Technology, extend a heartiest welcome and regards to our honorable guest speaker, Dr. Sanjay Pachauri, Professor and Dean R&D from IIMT College of Science, Engineering, Greater Noida, respected Dr. Poonam Pandey Ma'am, Director IIMT College of Science and Technology, Dr. C.S. Yadav, President IIC, Dr. Mohit Arya, Convener IIC, all the other dignitaries, coordinators, faculty representatives of IIC, all the dear students, and my dear attendees. But before we move ahead with today's IIC workshop on intellectual property rights and IP management for a startup, I find immense pleasure to introduce you all with our guest speaker and brief you all about his accomplishments and achievements. Dr. Sanjay Pachauri is working as Professor and Dean R&D IMT College of Engineering, Greater Noida. He obtained PGD-ITM, APG-DCA, MSc Computer Science, MTech Computer Science, MBA IT, MCP, MCSA, MCSE, and PhD Computer Science and Engineering, and he has also been throughout first class since his graduation days. He possesses more than 22 years of experience in academics and research in India. He had also served as professor and dean with the Department of Computer Science and Engineering at IMS Unison University and Excel Institute of Management and Technology, Mathura, UP, for 3 years each. He had also been a member of Academic Council, Faculty Council, and Board of Studies of IMS Union University. Not only this, he has also served as editor for Pragyan, Journal of Information Technology, and also as member of Editorial Board, International Advisory Board, reviewer for several international journals like from USA, Houston, Australia, etc. Not last but not the least, currently Dr. Pachauri is also guiding 5 scholars for their PhD work, and 6 PhD degrees have also been awarded under his valuable supervision. So without much ado, I would humbly request Dr. Sanjay Pachauri to grace this platform and begin with today's workshop. Thank you so much, sir, for giving us your precious and valuable time for this workshop. Thank you, sir. The platform is yours.
Thank you, Dr. Disha. Thank you.
Thank you, sir.
Before starting our session over IPR, I would like to share my screen first. So why actually we needed this IPR? IPR's journey is approximately 300 to 600 years back. This journey was started. This is not a very new journey. So before knowing that what actually the IPR and what it provides us as an applicant or as a scholar who is getting this particular patent in his own name. So let us go through the phenomena of the patents, what actually the patents are, and when we are learning about the patents, it's important to understand whatsoever the topic we are going to study. We should know, okay, what is actually the importance of going through that particular topic. So before going through this patent, it's important to understand exactly what patent are and what they actually measure. The existence of first systematic use of patent can be traced back to the 15th century in Venice. The Venetian patent statutes granted patents for any new and ingenious devices which is not previously made. It means whatsoever the new invention actually at this particular 15th century in Venice, this particular advantage is also given to these type of scholars. However, our new or whatsoever the patent system we are following right now, it becomes into the picture in 17th century by the British patent system that is considered to be the first modern patent system. Prior to that, patents were awarded by English monarchies to favor few scholars in the form of privileges, monopolies over trade, and premium prices over the certain goods whatsoever they want to, or they are going through this patent system. So few foundation keywords are there which we should note whenever we are going through this particular IPR session. These particular foundation words are very much important to us as well. So that foundation of the patent system consists of words like favorite, privilege, monopolies, trade, and goods. Monopolies over trade lies at the heart of the conducting a profitable business then and now. Innovation comes later. In the previous time, monopoly was there, but in our modern system, innovation comes into the picture, and innovation comes later when there was a need to identify a fair way of avoiding such trade monopolies than just being friends or family of the monarchy. So patent thus measure the potential of an innovator to conduct a profitable business via trade monopolies. So few rationales behind the patent system are as well. What they are actually, patents are a reward given to inventor by the state. The award takes the form of a temporary monopoly, because monopoly, as we are going through our economics, if somebody is an economic scholar, they are very well understand that monopoly is always bad for the society. So here we are giving the temporary monopoly, not the permanent one, which is the protection term, usually 20 years. During this time, no one but the inventor can make, use, sell, offer, import or export goods protected by his patent. At least no one can use any of these things without the prior written permission of the inventor. This is actually the benefit. So why reward is given to the inventor? Why it is needed, and why we are thinking about to giving any reward to the inventor? This is just because of the temporary monopoly is an incentive to carry out a research that requires not just ingenuity and hard work, but also substantial investment as well. Research and innovation is also a risky business. It can take 10 of years or more than that before an inventor's hard work and investment bear fruit. If a particular investor, if a particular researcher is doing a research over a particular part or over a particular technology, it might take 10, 20 or 30 years. So the entire life, he can invent a single thing after 30, 40 years of time and a huge investment. When the particular time comes to get out to enjoy the fruit, and if this particular temporary monopoly is not available, then how can he get out the taste of his fruits of this particular 30 to 40 years of hard work? In such cases, patent represents the light at the end of the tunnel where the researcher can reap the benefit of a temporary monopoly. So a classic example of this phenomenon can be found in the pharmaceutical industry. And this is very well known, and we all have seen in the last more than 2.5 years in this global pandemic of COVID-19. This is the fastest drug research in the entire globe, COVID vaccine. And the entire world was on a platform that this particular drug will not be patented, as we have to provide the benefit to the entire society. That's why this particular drug was not patented. Else, if this particular drug was patented, then the cost of this particular drug was so high. So the phenomena can be found in the pharmaceutical industry. Research into a drug Development can incur billions of dollars of the investment. Thereafter, a new drug have been undergone many years of testing and regulatory approval procedures. It can be argued that without the trade monopolies over their novel drugs, the big pharmaceutical companies would have no incentive to carry out long and expensive researches. Many drugs, as we know them today, would not be on the shelves of the medicine shops without the incentive provided by the patent system. So, we know that the innovation and temporary monopoly are the heart of the modern patent system, but there is a third aspect as well, which we should know. Third aspect that we need to talk about, it is the very reason why you and I are here at this moment of discussion of this IPR, patent information. The temporary monopoly given to the inventor comes at the price of disclosure. Yes, the patent data is public. Whatsoever we are going to file as a patent, that will become the public. All patent offices globally are required to publish patent at least 14 months from the date of filing. This way, anyone from the public can learn and improve upon the innovation. This aspect of the patent system fulfills the social aspect of the knowledge dissemination. So, what is the importance of actually the valuable patents? As we discussed that patents are temporary monopolies given to the inventors as a reward for the genuinity and the risk, the following graphic shows the patent filing trades in the top 5 patent offices in all around the world. This is actually the representation of what was the scenario of the patent by 1980 to 2018 till 2010. We are taking 5 topmost countries: China, Korea, European Patent Office, Japan, and USA. In 2000 till 2010, approximately 5 lakh was a very fast range where all of these countries were moving plus or minus. But by 2010 to 2018, within next 8 years, just check out the graph of the China. This particular graph increases exponentially.
I'm sorry, sir. Sorry to interrupt you, sir. Sir, your presentation only showing the first page.
Only showing the first page.
That is title page, sir.
Just I have to check it out.
Okay.
Now is it moving?
Yes, sir. Now it is moving, sir.
So I was discussing over this particular slide where we were discussing about what is the trade, what is actually the scene of patent filing in topmost 5 countries: China, Korea, European Patent Office, Japan, and USA. Till 2010, this was approximately 5 lakh patents per year by all the countries, plus or minus. But by 2010 till 2018, the graph of China filing in a patent exponentially increased, and they reached till 15 lakh. 5 lakh to 15 lakh, 3 times in just 8 years. None of the country is about to touch. Nobody is nearby the China. Now, is it the slides are moving or not? Anyone may help me to show this thing?
Yes, sir. Slides are moving.
Right. Thank you. The study rise in the patenting shows that inventors really respond on the incentive of temporary monopoly. Over 3 million patents are filed globally per year. Needless to say, all patents are not the same. There is a significant variance in their technical and commercial values. Empirical research has shown that half of the estimated patents value belongs to only 5% of the entire patent population. This is where the work of a business patent analyst must include to efficiently search relevant patents and differentiate more valuable patents from the less valuable patents. We can understand this particular example by within the scenario which is we have faced within this last 2.5 years. The research done in the field of vaccination for COVID-19, the highest priority was given to the vaccination for COVID-19 to search out the vaccine for the COVID-19. That is another issue that the entire globe was ready not to patent this particular drug. Otherwise, this particular drug invented by our pharmaceutical industry was having the highest priority to file a patent. Innovation is known to the drive economic growth, making the lives to everyone better. So the innovation was added later on in this IPR section. Why this innovation was added later? Because it was found that this particular innovation, it can change the life of everyone. This is just to benefit to the society. So, but if any benefit is giving to the society, that has to pay some cost. So these benefit comes at a price. Anyone who studies economics fundamentals would know that monopolies are always bad. They create deadweight losses for the society. Hence, the job of the patent system is to strike a delicate balance between the benefit to the society and the evilness of the monopoly. This balance is achieved in two ways that we have already discussed, but I would like to summarize it again so that the point may stay. First, patents are temporary monopolies. These are not monopolies. Temporary monopolies means the inventor can enjoy the benefits of that particular patent for maximum of 20 years from the date of the filing of the patent. After this 20-year time span, this particular data is public. Even this particular data is public by the very first day when the researcher is going to file the patent. But after 20 years, this particular patent released to use by anyone in the society, anyone can use without any permission, written permission by the inventor. So this monopoly is broken by this way. Temporary. Why this temporary? Temporary because a patent provided protection to its owner for the term that is usually 20 years from the date of the filing. All patents that have lapsed, expired, or abandoned come in the public domain as a free knowledge that anyone can use. Second thing, the guarantee of the exclusive rights come at the expense of disclosure. So patents are public knowledge and anyone can learn and build upon them, but making knowledge more global and accessible. In this order, for the patent system to function in the healthy manner, it is important that the evil of the monopoly do not overweight the benefit of the society clause. Here lies the importance of valuable patents. That's why the valuable patents are, of course, they are the benefit of the society. But if the monopoly is there, so we have to make a balance in between the monopoly and the benefit of the society. So we are going to free all of these patents after a span of 20 years from the very first date of the filing of the patent. So since the monopolies are bad for the customers, the consumers, it is important that only valuable patents, that is, which are truly novel and inventive, are granted patent protection. Guaranteeing a weak or invalid patents will allow the patent holder to accumulate profits at the expense of the consumer. The welfare losses are more than just the losses to consumers due to monopoly pricing. third party may be prevented from using a patented technology out of fear or infringement, even though the invention was not novel in the first place. That granted patents that are weak or invalid may also potentially obstruct and diffusion of the technology. Third parties have been known to have low incentive to challenge a patent unless they are directly not affected by this. So what is actually the patent life cycle? This is all about the patent, what patent is and why we have to go to the patent, and how we are going to make a balance in between granting the temporary monopoly and the benefit to the society. But what is actually the life cycle? The actual
Sir,
life cycle. Yeah, please.
kindly, sir, see once more. Actually, PPT is not running again.
Again, PPTs are not running. What is the disturbance in between all of these? Just I have to check it out. Is it visible?
Yes, sir. Now it is visible, sir.
It might be an issue of slow network, I think.
Okay.
What is actually the patent life cycle? If we would like to understand what actually the patent life cycle is, so to understand the patent life cycle, the modern patent system is characterized by a lengthy and sophisticated examination process. Every patent has to undergo with a test for their novelty, non-obviousness, and industrial applicability. The three key criteria for a valid patent. What are the three key criteria? They are undergo novelty, non-obviousness, and industrial applications. These three are the valid criteria to judge a particular patent. So before being accepted, or this particular patent should be accepted, or we have to refuse that, these three criteria, we have to check it out. A granted patent can be challenged by any of the third party in various forms, adding to the length and complexity of the patenting process. The figure below is a simplified version of the patenting process, in most taken by care by all of the patent offices. This is the priority filing. It means in this particular time, we are going to file our patent. Dr. Mohit, is it visible now? The slide is changing or not?
Yes, sir. It is changing, sir. Now.
Right. So in this particular day, we are going to file our patent. It might take 12 months to the foreign PCT filing, or it will take 18 months till the publication. It means whatsoever the patent is filed on the very first day, it will take 18 months to publish that particular patent. So that because on the very first day, we are going to take out our AFR, acknowledgement of the filing receipt, but publication on the public domain it will take the time approximately 18 months. Then an examination will be conducted. Inventor has to undergo with the examination part. In this particular examination, two cases might happen. Either a patent will be granted or a patent may be refused. So granting procedure might be there, or the refusal process might be there. So this granting or refusal, it may take approximately 5 years from the very first day of the filing of the patent. So a particular inventor can get out the patent on his or her invention approximately 5 years after the 5 years by the very first date of the patent. After granting of the patent, there might be an opposition. It means anyone can challenge this particular patent. Or if in the case of refusal, if you are getting the refusal, you may again make an appeal to the board that on which ground it is refused. I am making an appeal, and we can go through the appellate board. This is actually the life cycle which is taken care by the patent offices around the globe. You will notice from the above previous graphics, that patents are not one-shot action. It takes on an average even 5 years to get a patent grant decision. This time is also called patent pendency. This term is very much important to know what patent pendency is. and how to reduce this patent dependency, because 5 years is a very big time. It's a crucial time when we have discovered a new innovation, and after 5 years, whenever I'm going to take out the patent in my name, then after 5 years I'm going to make it commercialize, the cost of this particular product will be multiple fold. So during this time, innovation does not necessarily come to a stop. Key investment and technology commercialization decisions are taken. Product marketing and go-to-market strategies are prepared. Follow-on innovations and investment in complementary assets are made to make the most of the granted patents. So we have to be very careful about all of these things, because within this duration, we have to prepare ourselves in this regard. So big companies often outsource to manage all of these things. What actually the industries are doing, big companies or the industries are outsourcing the management of patent lifecycle to professional law firms. Here, the law firms comes into the picture to take care of all of the legalities in between the industry and the patent offices. So patent management constitutes all activities that enables firms to reach their strategic objectives. It encompasses identifying inventions, filing applications, managing patent offices, whatsoever the actions are taken care by the management patent offices, monitoring status, if any fee or paying a renewal fee is there, so paying of the renewal fees, negotiation of the contracts, identifying complementary investment strategies, and much more. There are so many things which we are taken care by these law firms. All these efforts lead to a self-selection of the most valuable invention, since parties will only pursue application and make further investments on inventions that show potential. Dr. Mohit, is it the slide number 21 over your screen? May you confirm me,
no,
please?
Sir. No, sir. It is slide number 20, sir.
20. Right. That's why I made it confirm that this is slide number 21 or not. Now is it 21?
Yes, sir. It is 21, sir.
While it is necessary to ensure that only truly novel inventions are granted patent protection, the long pendency time are also a cost of the innovation ecosystem. So here the word innovation ecosystem, and this we have to take care of when we are going through a particular any of this industry or any of the company, any of the production firm. This time is very crucial to us. We have to manage this time. So even this time is also managed by these patent offices as well. The long pendency time are also a cost to the innovation ecosystem, and hence the society, because society is getting this particular product after 5 years minimum. So product life cycle are getting shorter, which means innovator have less time to develop, roll out, and exploit their inventions profitability. If a new technology can replace an older technology in 5 to 10 years only, then how can an inventor justify the cost of this 5-year patent pendency? अगर 5 साल उसके pendency में चले गए, and he is having only the time, so next 5 to 10 years to cash out the crop, because he is having the time of 20 years, but a new technology comes in between, which is better than his technology. So how he will take out his all profit margin? So these offices are also taking care of this patent pendency time, and that use a 20-year patent protection term. These challenges are not new in last 300 years. So within these 300 years, all these challenges are taken care by. These challenges are not new for the 300 years old history of the patent system. So patent offices constantly come up with measures to ensure faster pendency time, hiring more examiners to clear backlogs, faster first office actions, to ensure self-selection of the serious inventions, putting processes to weed out weak patents. To name a few, innovators also find new ways to use patent protections in their own ways or by using their legal forms. So why we should go through the patents? What are the motive factors which we have to take care of? So we should file a patent. Here we are having some motives to file a patent. As we have discussed so far, the traditional motives of the file patent to obtain exclusive rights over an innovation. The patent holders can then enjoy the benefits of the temporary monopoly to run a profitable business. The method of appropriation involves either making and selling the innovations exclusively or extracting licensing and royalty income from others who are allowed to use the invention. Here the royalty means if a particular inventor is not able to go through this production, he may sell this particular technology to any of the person so that they can go through and they can product and they will pay the royalty against that. So here are some motives to file a patent again your technology or again your innovation. What is the very first is? Very first is blocking competitors from entering into the technological domain. If you are having a patent over your technology, over your innovation, you are blocking competitors, because for 20 years you are having the sole power. Nobody can take out your technology. Even your technology is on the public domain. Anyone can go through that. Anyone can learn the technology, but they will not fight in market because you are having the temporary monopoly over that. So you can stop your competitors to fight into the market, and the entire profit from the market is yours. That's why blocking of the competitor is a very good scenario if you are having the patent. Then next is increasing bargaining power. Suppose you had made a particular patent over your technology, and after a few years, suppose on 2021 you have filed on the very first January, you have filed a particular patent. After 5 years, on the very first January 2025, a patent is granted in your name, and for 5 years you till 2030 you were played in the market as you want, and within the 5 years you have made your desired profit. After that, you would not like to run this particular business in the market. Even for next 10 years stage 2040, the patent is in your names, and none of the competitor may fight you in the market. Now you want to sell your company, or some merger or acquisition type of scenario is going on. So you are having the better power to bargain with this. Whenever you will sell this technology to anyone, you can easily bargain that we are having the patent in our name for the next 10 years. So nobody will fight you as a competitor into the market, and you can earn a lot. So the better bargaining power is also available by going through this particular patent into your name. Then securing freedom to operate. You are having the freedom to operate. Freedom to operate is a term used in the patent prosecution terminology that gives any producer the right to make or sell products in a certain market without infringing upon patents held by the third parties. It is the responsibility of the manufacturer who are planning to introduce their products in any market to carry out the freedom to operate analysis, FTO analysis. In industries such as information and communication technologies, patents have vague boundaries. Products are usually made by combining various technologies, and players can be less known by these. So it is particularly challenging for a firm to carry out a flawless freedom to operate before introducing their product into the industry. This is again a particular benefit. Then we are having the gain time for evaluation. We are also getting the gain time to evaluate, okay, where we are and what is our scenario. For most innovations, there is uncertainty about where the actual market might exist. The inventors themselves face uncertainty due to investment or time pressure. The delayed examination process gives time for applicant to figure out these uncertainties before deciding to proceed with a patent application. This includes looking for a patent licenses and investors. Earlier in the course, you saw that patent life cycle can even last up to a decade. So enhance reputation. Whenever we are having a particular patent in our name, we are having here, we means the industry, for which industry we are working, all of these things. Or if we are having a patent in our own name and we are, so here we means I am having the patent in my name, but what I am going to do with that particular patent? I am going to establish a company. I am going to start my startup. Here, the company and all of these things are actually the startups, because whenever the new technology is developed by me and patent is in my name, I am going to sell this technology's product into the market through my startup. So I will go through my startup. Here, my startup will have that particular patent which is in my name because the startup belongs to me. So my startup is having a reputation. That is having another reputation. This is something like Tata Nano car. Whenever this particular rumor was there in the market that Tata is going to launch a car within the range of 1 lakh. So the specific name was given to that particular car, lakh takiya car. 1 lakh take ki car. Taka means the currency, the value of the money. So by launching that car, Tata Motors launched, and Tata Motor got more than 400 patents in the design of that particular car. After getting the patents, they launched that particular car into the market. That's why there was no other competitor. Otherwise, there were so many car industries are there who can make the replica of the car and they can get out the benefit. So they are having an enhanced reputation into the market whenever you are having your startup is having any of this patent in the name of you or your company. Or against an infringement suit, suppose you or your startup is having this particular patent into your name and some competitor is there who made that similar product by using the same technology into the market. So this is again falls under infringement rule. So you or your company can directly file a suit against the infringement of the patent law. So stacking intellectual property is a common practice among top ICT firms where the threat of the countersuiting is enough to prevent many patent related lawsuits. You can, or we are having, I've given this particular line over here specifically. Read about this famous case. We are the famous case again, LinkedIn. LinkedIn is having the famous case against this. Then we are having our priorities. We can secure our priorities. The motive might be important for applicants looking to target geographically dispersed market, that we are very much secure and our priorities are very much secured, and for the next period we are having the time frame even for this, and all of these securities and all of these priorities were decided in this Paris convocation. There was a convocation, international convocation was there. So in this convocation, this particular priorities were decided. The patent applicants have 1 year after making a priority application to extend their application to another country. We can move to the another country even. Even you are filing a patent in India, now you want to sell your product into Canada, you have to move to that country as well. You have to file that particular patent into the Canada and you can move over there. This time period can be extended up to 30 months. Normally it takes 1 year, but it might extend till 30 months. It means 2.5 years by filing patent under the Patent Copyright Treaty, PCT, which was taken place in Paris convocation. The motive is to rate granting time for evaluation and motive to defensive publication, because they have to evaluate that particular technology into their country, if the type of thing is available into their country or not, if or are you not falling under any infringement rule. So all of this about the IPR for the startup and what are the motives, why we should file, what is the procedure, what is actually the time frame. This is all from my side. If anyone is having any query, you are most welcome. Thank you, Dr. Disha. This is all from my side.
Thank you so much, sir, for giving out your precious time, and your valuable inputs will definitely benefit our students and all their attendees. Now, as we are moving towards the conclusion of this workshop today, I would request humbly our convener, Dr. Mohit Arya, for the vote of thanks. Mohit, sir, over to you.
Firstly, I would like to thank Dr. Sanjay Pachauri, sir, for his valuable lecture at IPR. He enlightened us by telling about Venetian patent, characteristic of patent, classic examples in pharmacy, as the fastest drug research are over the globe, as the drug cannot be patented because of the cost. He also said innovation and temporary monopoly is the heart of the modern system. He told empirical research shown half of the estimated patent value belong to the only 5% of patent population. His words were, patents are temporary monopoly in spite of the monopoly. Patent life, he tell us about the patent life cycle. He tell us about the at least patent cooperation treaty that was at the last slide of his speech. So I would like to say his valuable knowledge enlightened us and IIMT College of Science and Technology very well. Once again, my heartfelt thanks to you, sir. Thank you, sir. Sanjay Pachauri, sir.
Thank you, Dr. Mohit.
Thank you, sir. I would also like to thank Dr. C.S. Yadav, our president of Institution Innovation Council. And I would also like to thank Professor Dr. Poonam Pandey, Director, IIMT College of Science and Technology, for their valuable time to be a part of this workshop. Thank you, ma'am. Thank you, sir.
Thank you, Dr. Mohit.
Thank you, Dr. Mohit, for giving a heartfelt thanks to our respected Dr. Pachauri, sir, for this session. Thank you so much, sir. On the behalf of whole fraternity, once again, thank you so much, sir.